Bismillahirrahmanirrahim. What do you mean by jurisdiction? The CPC or none of the substantive or procedural laws define the term jurisdiction. Black's Law Dictionary defines jurisdiction as a court's power to decide a case or issue a decree. So from Black Dictionary we can see a definition about jurisdiction, a court's power to decide a case or issue a decree. Jurisdiction may be defined to be the power or authority of a court to hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. In short, jurisdiction is whether the court has the right to hear the particular case. Any decision passed by the court which doesn't have jurisdiction to pass the decision, then the decision would be a nullity. So it is very important. If any court has no jurisdiction, but if he passes any decision, then it will be nullity. So in legal term it is said coram non juris. Jurisdiction of the court. Jurisdiction of the court may be classified into the three categories. Firstly, territorial or local jurisdiction. Number 2, pecuniary jurisdiction. And number 3, jurisdiction as to subject matter. Territorial or local jurisdiction. Every court has its own local or territorial limits, beyond which it cannot exercise its jurisdiction. Generally, every suit shall be instituted where the subject matter is instituted or where the cause of action has been arised. Section 16 to 21 of the Code of Civil Procedure 1908 deals with territorial jurisdiction. Okay, next, now we are going to discuss about pecuniary jurisdiction. It is very important to understand the jurisdiction of a civil suit. Pecuniary literally means related to money. Section 6 of the Code of Civil Procedure 1908 deals with pecuniary jurisdiction. Pecuniary jurisdiction sets the pecuniary limits on the jurisdiction of a court. Section 6 provides that a court will have jurisdiction only over those suits, the amount or value of the subject matter of which doesn't exceed the pecuniary limits of its jurisdiction. And Section 15 provides every suit shall be instituted in the court of the lowest grade competent to try it. So it is very important section to understand about jurisdiction. That means pecuniary jurisdiction. Every suit shall be instituted in the court of the lowest grade competent to try it. Court of the lowest grade competent to try can be ascertained with pecuniary jurisdiction. At present, the pecuniary jurisdiction of the civil court is as follows. The Court of Assistant Judge. The pecuniary jurisdiction of an assistant judge is up to Taka 2 lakhs mentioned under Section 19, subsection 1 of the Civil Courts Act. And the courts of senior assistant judge. The pecuniary jurisdiction of a senior assistant judge is up to Taka 4 lakhs mentioned under Section 19, subsection 2 of the Civil Courts Act. And the courts of joint district judge, the pecuniary jurisdiction of joint district judge is unlimited. Suits amount to Taka 4 lakhs to unlimited lie before joint district court under Section 18 of the Civil Courts Act. Okay, next, the Court of Additional District Judge. According to Section 21 of the Civil Courts Act 1887, it has no original jurisdiction. So from this we can understand that the additional district judge has no original jurisdiction. It has appellate jurisdiction only, or revisional jurisdiction. It has jurisdiction to hear appeal from a decree or order of an assistant judge or joint district judge which value doesn't exceed Taka 5 lakhs by the supervision or reference of a district judge. If a district judge doesn't refer the time, the additional district judge won't be able to hear that. Additional district judge will exercise power as same as district judge when district judge will assign him. But if the district judge doesn't assign him the time, he won't be able to hear that. And next, the court of the district judge. According to Section 21 of the Civil Courts Act 1887, it has no original jurisdiction. So from this line, we can easily understand that additional district judge and the district judge has had no original jurisdiction. It has jurisdiction to hear appeal from a decree or order of an assistant judge or a joint district judge which value doesn't exceed Taka 5 lakhs. Okay, next, lastly, now we are going to discuss about the High Court division. According to Section 21, subsection 4, it has jurisdiction to hear appeal from all decrees or orders of any joint district judge, the value which exceeds Taka 5 lakhs. If the value exceeds Taka 5 lakh, the time it will hear by the High Court division. Otherwise, under 5 lakh, the time it will hear the court of district judge or additional district judge. Okay, now jurisdiction as to subject matter. Different court has been empowered to decide different types of suits. Under the Code of Civil Procedure, a civil court has jurisdiction to try all suits of civil nature unless they are died. Section 9 of the Code of Civil Procedure stated that the court shall have jurisdiction to try all suits of civil nature, excepting suits of which the cognizance is either expressly or impliedly barred. Okay, in this section we can see an explanation: a suit in which the right to property or right to an office is contested. So if in a suit the right to property or right to an office is contested, is a suit of civil nature. Such a right may depend entirely on a decision of question as to religious rites or ceremonies. Okay. Apart from above jurisdiction, civil courts have a revisional jurisdiction. So from this line we have understood that a civil courts also has revisional jurisdiction. Section 115 of the CPC provided that the civil revisional power can be exercised by the High Court division and the district judge. So only two courts can exercise a revisional power. These are High Court division and the district judge. So that's all about jurisdiction.